Hello everyone and welcome back. This is module 6 of the wholesaling class. In this module, we are going to be talking about control of the property. We're going to be going into different laws that you need to be aware of. We're going to be diving in deeper and talking about our buyer's list, which we've touched on in several of the modules already. We're going to be talking about how to create that buyer's list and the type of information that you need to be collecting. We've got a whole bunch of stuff in this module. Take some good notes. There's some good learning to be done here. Now, as we do in every module, I need to give you the disclosure. I'm not a licensed attorney, accountant, financial advisor, real estate broker, real estate agent, or any other licensed individual. Even if I had a license, I'm not acting in that capacity. This is just information that I've gone out and made some good money in real estate investing with that I want to share with you guys. So hopefully that's okay with everybody. Let's go ahead and dive in. I want to talk about some of the laws that you're going to need to be aware of. And to do that, let's talk about the different types of laws that there are. So legislative law is something you need to be aware of. These are laws, statutes, and codes that are created by the legislative branch of the government on the federal level, the state level, and the municipal level. So when we talk about laws in the education, we're mostly talking about federal laws because laws can vary state to state. And wholesaling is something that I found that there's a lot of variance between different states. So you want to be familiar with your state legislative law around wholesaling. And the best place to do that is to contact your state's Department of Real Estate, or DRE. And then there's also laws on a municipal level that you're going to need to be aware of. But a lot of times what I've found is that those laws on the municipal level line up with what the state has in mind. However, it is something that you need to be aware of. Now, let's talk about common law. Common law is the body of law developed primarily from judicial decisions based on custom and precedent, unwritten in statute or code, and constituting the basis of the system in all of the U.S. states except Louisiana. I don't know why except Louisiana. That's just what I found when I was pulling up definitions of common law. But let's break that down. What does that mean? Because it's a very dry dictionary definition of common law. Basically, where common law comes from is from other lawsuits that have happened in the past. So it's the judicial branch, it's the judge's job to interpret the legislative law. And those interpretations have an effect on how the law is judged moving forward, how the law is interpreted by judges moving forward. That is called common law. So if a legislative law says, for example, maybe your state law says that you can't advertise wholesales to the masses; they have to be on an individual basis, and you send out a mass email to your, to just your contacts. Well, the law doesn't necessarily say that you can't mass communicate with people that you've had relationships with in the past. So that's where a judge comes in and decides how to interpret that law. We know where in this example where the law says you can't mass advertise, you have to only advertise wholesales to people that you've had relationships with in the past. Well, you did that, in the email, but someone didn't like it because they said, well, you mass advertised it, and you said, yeah, but it was only to people that I've had relationships with in the past. In that type of conflict or lawsuit, a judge is going to decide how to interpret that and whether he's going to side with one side or the other. So that common law, if that situation has happened in the past, a judge in the present is going to base his decision based on decisions that other judges have made in the past, so that the enforcement of those laws stays consistent. So you have to be aware of that. I know that's like a lot to digest, but it's important to understand how the legal system works and what the common law is out there. Now, the best way to be aware of common law, because it's a little harder to find, because like it says here in the definition, it's unwritten mostly. So the best way to do that is to work with an attorney. You need a relationship with an attorney to understand common law. Now, a lot of that is discussed in local real estate investing communities, such as RIAs, real estate investor associations. As far as I know, RIAs operate in every state, in most most metropolitan areas. So, use Google go out and search for your local REIA, REIA, and see if you can't start attending some of those, because they're going to talk about a lot of those local precedents and laws, and that's going to be an important part of understanding the common law in your area. And then the next is agency law. This is a relationship where one party has the legal authority to act in place of another. One perfect example of this in the real estate world is having a real estate agent or a realtor. By law, a licensed real estate agent can act on your behalf to negotiate a property. Now, there's certain laws with that. They have to act in your best interest, and they have to act in accordance with what you've asked of them. So if you said, hey, I can't go above $200,000 on the purchase price, please negotiate it as low as you can, they can't go above $200,000 on the purchase price because that's what you said, and they're acting as your agent in that case. So understanding those different types of laws is going to help you navigate the wholesaling realm. Don't get overwhelmed by this. It's something that you're going to learn as you go. You don't need to be a lawyer in order to go out and wholesale. Get out and get your feet wet. You're gonna learn this stuff as you go, but just be aware of it, be cognizant of it, and be proactive in understanding what the legislative law, the common law, and the agency laws are in your area and in your state. Now let's talk about contracts. So the contracts that you'll need to be aware of and that you should really study, the most important one is probably the real estate purchase contract. Now this can vary state to state. We talk about this a lot in the finding off-market deals class, or the off-market deals on tap class. Having a good understanding, I said this in a previous module, having a good understanding of the REPC is going to help you with negotiations, but it's also going to help you make sure that you're following those laws. So have a good understanding of the REPC. Always carry a few of them with you, because you never know when you're going to find a good deal. Also, you need a good wholesale contract. So the real estate purchase contract is what is the contract that you'll be using with the seller of the property. But as a wholesaler, we're obviously not going to buy that property. We're just going to flip it to another person. So you need a contract with that person as well. Make sure that you use those wholesale contracts. And I've got some that I've included in the education, so you can use those. Those are for example purposes. But also, and if you do use those, make sure you have an attorney review them. But also, a great place to get a wholesale contract is with your local attorney. He's going to understand the laws of your state and the laws of your area better than just a generic wholesale agreement. So they may be able to provide you with some more insight and a wholesale contract that protects you better in the state that you live in. Also, something that's very important that you'll use in your long analysis period that we talk about in the off-market deals on tap class is the seller disclosures form. Anytime you put a property under contract, it's required of the sellers to return to you what's called seller disclosures. And this is where they get the opportunity to disclose the condition of the property in great detail. And you'll use that as you put together your construction estimate. And I'm sure it's something that, an educated buyer is going to want to see before they purchase the wholesale deal from you. So the seller disclosures are going to be very important. Now, let's dive in and talk about buyers. I know I've touched on a buyer's list and the importance of that. Let's kind of dig deeper into that. Finding a buyer. There are an abundance of buyers out there, and there's a lot of people out there that are just waiting for you. So finding buyers shouldn't be a problem if you know what to do. And part of that is just having a good product. There's a lot of people out there that want to be real estate investors that maybe need, to start with a wholesale so they can get in and get their feet wet in real estate investing. But there's also a lot of really experienced wholesalers out there, real estate investors out there that just don't have the time or the desire to go out and find properties. If this is a skill that you've developed and that you're good at, you could be a real asset to that person, and you could make a lot of money working with individuals like that. So your strategy should be to sell the property as soon as possible for cash and at no additional expense. You're going to get really good at through this process. You're going to get really good at finding a property, knowing, as long as you are familiar with your buyers, you're going to know which buyers that's going to appeal to, and you can turn and reach out to those buyers directly and ask them if they would like that deal at a fee. Like I said, the fastest I've ever turned a deal was a $15,000 wholesale fee that I made, and I had the deal in my under contract for like 20 minutes before a buyer came in and purchased it from me with my fees. So always have your buyers list at hand so that you can move those deals quickly. And then your buyers list should contain specific information about each individual buyer that can be useful to you. So let's talk about some of the different ways that you can create that buyers list. Now, you can find buyers the following ways. The number one way is networking. Get out there to the RIAs, the Real Estate Investor Associations, network with other real estate investors, find where these people are hanging out and go hang out with them. And when you're there, talk to them. I've seen students that I've said, hey, go mingle at the real estate investor associations, and they just go sit in the corner and then they leave when it's over, right? And they don't talk to anybody. That doesn't do you any good. You need to, even if it pulls you out of your comfort zone, you need to be mingling with people. Talk to people. Ask them what types of investments they're looking for, whether it's fix and flips or rentals. Ask them, what price ranges they're looking for, what geographic areas they're looking to invest in, and then keep notes and keep that all in a centralized place so that you can review it often, be familiar with your buyers. And then when you're finding properties, you've got specific buyers that you can market those properties to. Real estate agents are a great resource. One of my favorites is the 3-foot rule. Talk to everybody that comes within 3 feet of you. You'll be amazed at how many people out there are looking for real estate deals, whether it's rentals or fix and flips, or even some people that are just looking for a house for themselves, right? They might be a potential buyer. Granted, a one-time buyer, right? And it's better to fill your list with people that are looking to buy multiple properties, and those are going to be investors. But don't discount anything. Your local hardware store. A lot of investors hang out at the hardware store because they're buying materials for their rentals or for their fix and flips. And that's where the 3-foot rule would come in. Talk to people while you're at the hardware store, right? Flyers, websites, business cards, bandit signs. All of these things work. Back to, when we were talking about ways that you can market to find properties. It also works for ways that you can market to find buyers. All of these things work. And again, everything works and nothing doesn't. So let's talk about closing. So you are responsible for the completion of the deal. You must attend all aspects of the deal until it's completed. So you're going to want to be at the inspection. You're going to want to be at closing. You're going to want to be at all of these places because you are a component in this deal and you're responsible to make sure the deal goes through. Your relationships can help you with this completion. So having a relationship with a title company, having the relationship with the agent, if there's an agent involved, the contractor, all of those things. These people can help you streamline the process to get the deal done and make it less work for you in the long run. The deal is done when money changes hands, and you should never. You should take your fee before or at close. So, what I mean by this: take your fee before or at closing. You can either accept the fee when you assign the contract, and we're going to talk about that a few bullet points down on this slide. You can take your fee immediately when you assign the contract to that person, or you can take your fee at closing. What I would suggest is get familiar with your state's laws, because there may be laws saying that you have to take that fee at closing and you can't take it before. I would never do a handshake deal where you get your fee after the deal closes, because then you're just kind of relying on that person to be truthful and honest. And you know what? Not everybody's truthful and honest. So make sure you protect yourself. Get your fee before or at closing. Talk to the title company if you choose to take your fee at closing, because they can make sure, they're a neutral third party in this transaction. They can make sure that you get paid. So make sure that you've got that relationship and that you're in open communication with the title company that secures your fee. They'll probably want to see your wholesale contract that you have in place with the end buyer. So make sure that you have that available for them. Issues to be aware of at closing: signing versus recording. Just because your buyer came in and signed on the property and the seller came in and signed on the property doesn't mean that the deal's done. Remember that the deal is done when money changes hands. So once it's all funded and recorded, that's when when the deal is complete. And recording, to define that real quick, what we mean by recording is that it's recorded at the county that the buyer is the new owner of the property. That only happens after it's signed for, the funds have been transferred, etc. Other things to watch out for: there are problems that can happen with wire transfers with certified funds. So just because someone initiated a wire transfer or dropped off a certified check doesn't necessarily mean that the deal's done. You want to make sure that it's recorded, because that's the last step. So as you're in touch with the title officer and your relationship at the title company, that's what you want to be asking them after closing is, hey, have we recorded yet? Have we recorded yet? Right? Because that's when the deal is done. Now let's talk about assignment versus dual close. There are two ways to transfer ownership into the new buyer's possession. One is assignment. This is where you take your wholesale contract and the rep C, and once the wholesale contract is signed and you receive your fee, you can create an addendum to that rep C where you transfer buyership over to the new buyer. So in a rep C, you're listed as the buyer, the current owner of the subject property is listed as the seller, and a simple addendum to that contract that you sign and the seller signs says something along the lines of buyer shall be whoever the new buyer is, right? You sign that, the seller signs it, that's easy. Now, some states don't allow assignment wholesale. I like assignment wholesale because it's very little mess, right? You don't have to raise funds. You can just flip the contract over to the new buyer and then they go execute it and they close on it and they buy it. But some states don't allow that. And also some sellers have a little bit of heartburn with that. Not many. I would say most sellers are fine with that, especially if you're setting the right expectations. As a wholesaler, when you're talking to sellers, you should be introducing yourself as, I'm a real estate investor and I'm part of a group of real estate investors. And just so you know, we may be changing the name of the buyer to a different entity or a different person because, I'm just one part of a group of these investors. If you're setting those types of expectations, it shouldn't be a surprise to the seller, but some sellers do have heartburn with that. And the way around that is to do what's called a dual close. Now, in a dual close, what you do is you close on the property, so you own it for a short period of time, and then usually within the same visit to the title company, you're turning around and then you're selling it again to the new buyer, to the person who's purchasing the property as a wholesale from you, obviously marked up with your fee. So that's two ways to do it. With the assignment, you don't need to raise funds. With a dual close, you do need to raise funds. You also need to be clear with the title company whether you're doing an assignment wholesale or a dual close wholesale. So be conscious of that. There are ways. Obviously, assignment is the quickest and easiest way to do it, but based on the laws or based on the attitude of the seller, that may not be an option for you. Either on every deal or on specific deals. So be aware that you can also do a dual close, and that's your way around your limitations with assignment wholesale. Now that wraps up module 6. We talked about the different laws, your buyers list, and the things that keeping track of your buyers, how to find buyers. We talked about the contractual control of the property. So that wraps up module 6. In the next module, in module 7, we're going to be talking about some issues and concerns that arise from both the buyer side and the seller side, as well as other issues that might arise for you as you're wholesaling. We're going to talk about those problems and we're going to talk about solutions to those problems in module 7. So I will see you over there.